everyone. Myself Virender Sharma, Public Administration Faculty at Vajiram and Ravi. We are going to discuss in the today's class with respect to Public Administration paper which has been recently conducted in the Mains 2023 examination. This year the paper was as per the expectations, and from the last few years this trend is becoming regular that the paper is coming in an average manner with conceptual part as well as the application part, and also the UPSC is incorporating certain schemes, and that's why the combination of this year's exam is also reflection of the same conceptual part, constitutional part plus schemes which has been recently introduced by the government, or the performance of those schemes have been related with state government, central government, or even the local self-government level. And some are the traditional topics like district administration, Kautilya, and apart from this union government, then judiciary. So it's a complete bag of the topics which has been there in the current year's exam, and it is good that we can expect very good positive results also from this optional in the upcoming results. Let us begin with the discussion from section A of paper 2. The section A, very first question is, Kautilya's Arthashastra is a theoretical work on the state and statecraft. Comment. That means the statement given in this question is correct, and when the question is about comment, we are given an opportunity either to support it or to go against the statement. In order to approach this question, we will follow the very basic understanding of the Kautilya's Arthashastra, as the question is a straightforward. Means what we can mention here in this question, we can mention about the Kautilya's Arthashastra was based upon two main principles, Palana and Labh. Palana is with respect to the preservation or maintenance of the people, and Labh is with respect to conquest of the territory. And based upon these two principles, the Kautilya advocated the theory of Saptanga or doctrine of 7 Prakritis. As a result, you can simply mention about in 7 points about king, whatever has been prescribed by the Kautilya for the king, then ministers or amatya, apart from that janpad, that is territory and its people, plus he talked about danda, so types of army also advocated by the Kautilya, plus kosh, he talked about imposition of the taxation, then mitra, he talked about allies and also the types of warfare with respect to the present scenario, that means strategic warfare, which will show that how Kautilya's contribution was also based upon statecraft, that means how the state is supposed to be run. And while writing the duties of the king, or in 2 lines, 3 lines, you shall also include that Kautilya has also advocated about the welfare is the prime responsibility of the ruler, and also to protect the people from various types of calamities, specifically natural calamities like fire, drought, flood. These are in the advocacies of Kautilya's Arthashastra. And after mentioning all these 7 Prakritis, a positive conclusion that yes, lot of principles advocated by the Kautilya's Arthashastra are even still relevant in the modern day administration and can guide the modern day statecraft, like disaster management, maintenance of law and order, welfare of underprivileged segment of the society, and that way a simple 150 words answer can be structured. Then second question, critics sometimes argue that bureaucracy is an impediment to nation's development. Analyze. That's also a straightforward question which can be derived from the topic bureaucracy and development, which is mentioned in unit number 2. So here in the first half of the answer, you may present the idea what is the role of bureaucracy in nation's development. That role of bureaucracy in the nation's development can be with respect to policy formulation, with respect to advice to the politician or political executive in the decision making, plus guiding the future of the policy through planned economic growth and development, plus suggesting for nation building, suggesting for social integration. These kind of 5-6 major dimensions can be taken in order to tell the role of bureaucracy in the nation building. Plus, we shall also include in this point that bureaucracy, with the help of various line agencies such as directorate, attached and subordinate office, also helps in the execution of the policy. By this way, we will play a very justiciable role to this question by explaining what bureaucracy is supposed to do in the nation building in form of policy formulation and in form of policy execution. And thereafter is coming towards the negative side, because here the question is also about critics argue bureaucracy is an impediment. Impediment is like restriction, impediment is like obstacle in the nation's development. That means in the second half, after mentioning what is the role of the bureaucracy, now we will come across various challenges or various problems which are created by the bureaucracy in the policy implementation or policy formulation. And for writing these points, we will use our knowledge from paper 1 as well. From paper 1, we all study about Max Weber's bureaucracy, taking some ideas from that, and like there is excessive delay in the decision making, which is very common criticism for bureaucracy, and it is often known as red tapeism. Apart from that, we can also use excessive political interference is also faced by the bureaucracy. Reason, we are a federal structure, so central government directions, state government informal directions upon the bureaucracy adversely affect the stage of the policy implementation. Plus, bureaucracy also suffers from occupational psychosis. This occupational psychosis is about resistance to change. Means I have developed my comfortable zone of working, and now you suddenly ask me to change my way of working. So if I have to adopt this new ways of working, I may be reluctant to adopt, and that becomes an internal challenge for bureaucratic institution. Plus, within the bureaucratic machinery, it is also true that whenever the training reforms are talked about, they are generally at a higher level, and the middle and lower level of the bureaucratic machinery, they have not undergone the training or refreshers working, which adversely affect efficiency of the system. However, in recent years, government have introduced Operation Karam Yogi, but at Mission Karam Yogi, but at the end of the day, its implementation is still at a lower pace, and it become a criticism also that the training program at middle and lower level of bureaucracy adversely affect the speed of policy implementation across the country. And also we may use bureaucracy also suffer from the point can be like there is mismatch between the qualifications required and the qualifications of incumbent officials. Is it? This is generally termed as trained incapacity. As per the Weberian criticism, that means the training is given for, that means educational background belongs to a separate field and you are working in a separate field. How? Let's say somebody have done agricultural degree from the agricultural university and working under e-governance project. So sometimes there appears this type of mismatch. A person may have been a medical professional and maybe MBBS doctor and working with any technological department. So sometime we require, however, it is a concept that you require managerial aspect at these higher position, but technically that becomes a dispute, and lack of awareness about the technology can adversely affect my decision making capacity as a bureaucrat. And in those conditions, I may not be a motivator or influencer for my subordinates. And that creates a hierarchical challenge within the team spirit and team working. These are all the different 5 to 6 criticisms which we can present in order to structure our answer as per requirement of the question. Then comes the C part. C part is also a direct one. 91st Constitutional Amendment Act successfully right-sized the Council of Ministers at union and state level. Comment. Again, the 91st Amendment Act, we have to remember, this is with respect to the size of Council of Ministers. And also anti-defection laws, one provision was amended, but that provision does not require to be mentioned in this answer. Here what we have to go, that at union government level there is Council of Ministers, and original constitution does not prescribe any limit with respect to Council of Ministers. So while writing the introduction for this question, we may use the philosophy of parliamentary democracy. Is it? That means there is parliamentary democracy in India which require existence of nominal head and real executive. At union level, that nominal head is president, and at state level, governor of the state. Similarly, the real executive is Council of Ministers headed by Prime Minister at union level and Chief Minister at state level. This can be a little elaborated introduction as per requirement of this question, because content in this will be very restricted and very limited because the question demands that way. Then we will, after writing this intro, we will come across to the explanation part. Within explanation part, we will mention the members of the council are appointed by the nominal executive on the recommendation of the Prime Minister or Chief Minister, as the case may be. However, original constitution does not talk about maximum limit upon the members of the Council of Ministers. And during the 1970s, 80s, we have domination of coalition governments at various state governments level, and also at union government level from 1989-90 onwards, again we have the number of coalition government at union level. And everybody wanted to be the minister if they joined the coalition politics. Therefore, the number of ministers were growing. This has forced the NDA government during the period of Atal Bihari Vajpayee to think about limiting the number of the minister. And in that context, 91st Amendment Act was passed. And by that amendment, two major constitutional limits were introduced at union government level and at state government level. So what was the limit introduced? At union government level, there has been introduction of Article 75 Clause 1A. Is it? This is what we all study in the GS as well as optional class, that the maximum limit shall not be more than 15% of total strength of Lok Sabha. And similarly, at the state level, Article 164 Clause 1A was added, and it also says not more than 50% of total strength of legislative assembly, state legislative assembly. That is the maximum strength prescribed. But at a state level, there is one more provision added, provided that the minimum strength will be 12. Maximum strength 15% of the total state legislative assembly, and minimum strength will be minimum 12 ministers including the chief minister can be there at the level of the state government. This is why the question is saying that 91st Amendment Act has successfully right-sized the Council of Ministers both at the center and state level. That is why this provision articles, that means 75 Clause 1A and at state level 164 Clause 1A, both can be mentioned so that your answer will become a combination of concept plus fact. And thereafter, the limit which is existing at the state level, minimum 12, it should also be added in order to fetch an extra score. And if you can also have word limit left with you, then also you may mention that for the UTs, that limit is 10% of total strength of legislative assembly. So in the Delhi, including chief minister, not more than 10% can be the total strength of the council of minister, and these three provisions are supposed to be mentioned. Plus one more article was also one more clause was also added, and it was like Article 75 clause 1b. That is an important point to remember because that will give you an extra score. And 75 clause 1b, it says if a minister is disqualified from being the member of house under anti-defection law, that person cannot remain in the office of the minister. This is the unique point to be remembered because maximum student will remember only 75 clause 1a and they miss 75 clause 1b. This 75 clause 1b will be a extra score marking point. Same way 164 clause 1b, that also says if a person who is a minister in the State Council of Minister is disqualified under anti-defection law, that person cannot remain as a minister on the grounds of defection under anti-defection law. On the grounds of disqualification under anti-defection law, the person will remain disqualified. And after mentioning these total 6 points, we'll reach to the final logical conclusion that on the basis of above, we can say, yes, 91st Amendment Act has brought the right balance in the context of size of the Council of Minister at union and state level, which has not been amended in the subsequent constitutional amendments. That way we can present this answer with concept, articles of the provision, articles of the constitution and conceptual explanation. It's a 10 marker, so do not require a larger explanation, and question is about comment. Statement is correct, so we are just supporting the statement. Next question, question number 1D. Is it true that the Finance Commission has been lending financial strength to the local bodies in India? Argue in favor of your response. Means the question is in the question form itself, because otherwise usually we get the statement and then we have to think it is right or wrong. But here the statement is also given in a question form, which will give you a opportunity to express your opinion. So idea here is that is it true the Finance Commission is giving strength to the local self-government through their recommendation. So in order to approach this question, what we will find that what is the constitutional provision of Finance Commission. Could be used for introduction purpose, that Article 280 of the Constitution talks about the establishment of Finance Commission by the President every 5 years, and as per Article 280 only, the Finance Commission can make recommendation for augmenting or improving the resources of the local self-government on the basis of a report of State Finance Commission. This is important to mention in this answer because that will tell you the constitutional position and constitutional provision for relationship between the Finance Commission and local self-government. Means according to this point, Article 280 of the Constitution authorizes the Finance Commission to make recommendation for augmenting the financial resources of whom? Local self-government. But it will be based upon the recommendation of State Finance Commission. In the earlier year, there was a question that is it required that the time for SFC shall be synchronized with the Union Finance Commission, and this time the question is modified in this way that the Finance Commission, do you think, make the recommendation for strengthening of the local self body. So by mentioning this constitutional provision, after that we will come on the 15th Finance Commission, because that will be our response to the answer. Is it? This is constitutional provision, and when we go for our opinion, so to make our opinion, I will use 15th Finance Commission. 15th Finance Commission has made major recommendations with respect to the local self body, and there are three major recommendations by them. One, they said total grants to local self government shall be rupees 4,36,361 crore rupees. This is for a period of 5 years, that is 2021 to 2026. We all know Finance Commission's recommendations got late by 1 year. Otherwise, they were supposed to make recommendation for 2020 to 25. But this is very unique situation where Finance Commission initially gave recommendation for just 1 year, 2020-21. And later on they submit the detailed report, and 5-year duration starting from 21 to 26. Those recommendations were given by the 15th Finance Commission as its complete report. So one recommendation they gave, total grants to the local self-government. Apart from this, of these total 8,000 crore rupees, they are going to be performance based grant. Means, are the local self-government implementing the recommendations, suggestions given by the previous bodies, schemes of the government for improvement of these institutions? If yes, they will claim around 8,000 crore rupees under performance based grants, and this performance based grant is basically for the new city and the municipal services which are required up to 450 crore rupees. And also there will be 70,000 crore rupees ₹70,051 crore rupees will be going for health grants to local self-government. This is in the context of the COVID vaccination programs as well, because for implementation of this COVID vaccine, we have incorporated the panchayat bodies. So panchayat bodies will also be part of your local self-government, and as a result 70,000 crore rupees is the total amount they have advocated for this health grants. And also the 15th Finance Commission also advocated for urban local bodies. That means there will be based on population plus specific needs of urban areas. So here the idea is the 15th Finance Commission has considered both the parameters, performance based parameters as well as need based parameters, in order to make recommendation for grants to the local self-government, and this is the highest grant recommended by any finance commission to the local self-government. So by taking at the number, it appears yes, the finance commission is working for strengthening of the local self-government. And not just this, a specific grant for the health sector is also advocated. We can call it sector specific grant advocated for the local self-government by the 15th Finance Commission. However, one of the biggest challenge for these grants execution is what? The center used to give this approval to the state government, and via state government these matters are to the local self-government. So if your state government is not participating in certain policies of the central government, then your local self-government will also be denied the benefits for participation in such schemes or program. And in that context, that could be the problem of center-state relationship, that could be problem of politicization of federal structure. But in provision terms, a constitutional body has recommended the more amount of money, because if money reaches to the local self-government, it will make them financially strong, and finance is the lifeblood of every organization. Without finance, how the panchayats will hire the workforce? How the panchayat will have infrastructure? So in that condition, neither the panchayat can spend money for any training programs, improving the quality of the workforce. So if the money will reach to these institutions, they can make plan, they can execute the plan, plus they can get the benefit from various centrally sponsored schemes or program. That is an overall idea. Then one last question of this question number 1, and this is about parliamentary democracy in India envisages elected head as the real executive of the state. Discuss. So it's a direct question about the parliamentary democracy . So we can give introduction about this parliamentary democracy, is it? And thereafter nominal executive and real executive. So in order to just explain this answer directly, we may use the constitutional articles, which will make our answer conceptually and constitutionally also up to the mark to score higher marks in this answer. And for that purpose, what we are supposed to do, article number 52. There shall be a president of India. So by this article, the position of president is mentioned in the constitution. For election, we have a separate set of articles which may not be required to mention, but in case you want to show more wider dimension, you can even include the president is elected by a process of proportional representation by single transferable vote, and in that way you may mention article 54 or 55. But before that, it is also important to mention article number 53, which talks about executive powers of union. So this article says, article 53, the executive powers of union shall be vested in the president, who shall exercise these powers either directly or through officers subordinate to him. That means power will be exercised by the president either on its own or with the help of the subordinates. So who can be these subordinates? These subordinates will come from article number 74, which talks about there shall be a council of minister, and the council of minister is to aid and advise the president in exercise of his functions. As a result, this article 74 talks about existence of the real executive, that is council of minister, plus these members will be appointed by the president under the provisions of article number 75. As a result, prime minister will be appointed by president. On his advice, other members will be appointed by the president. They can be holding office during pleasure of the president. They are collectively responsible to the Lok Sabha. These type of points are included under article number 75. And the two articles which are very important in order to justify this entire relationship are article number 77 and 78. That is also there. Article 77 generally talks about the entire work of the union government shall be conducted in the name of the president. Think about it. The work of the union shall be conducted in the name of the president. That itself is suggesting us that president is what type of executive? Nominal executive. And article 78 is important because it will say it is the duty of the prime minister to keep the president of India informed about the affairs of the union or proposals for legislation. So by this article, what is the interpretation we are going to make? Who is actually going to take a decision? So cabinet will take a decision and the prime minister is under obligation to keep the president informed about work or affairs of the union government. And by using these provisions, we can constitutionally present this answer that yes, the real executive is Council of Minister and whatever decision they will take is going to be guiding for the President of India. That's why the question will be simply reformed. Parliamentary democracy in India envisages elected head as the real executive of a state. Here the term is state, so it's again about government. It's not exclusively within the context of just the state government. It is in the context of the government. So you may, if you interpret it like it is for the state government, so just change the article for that purpose. And in that context, what you need to do, you need to go for articles which are mentioned for your state government. So nominal executive of the state. So as far as the state is concerned, when you talk about nominal executive of the state, there shall be article number 154, governor of the state. Executive powers of the state, that is 154, and governor of the state 153. That means both of them will be talking about this at a state level. Real executive at the state level, it will be guided by article number 163, 164, 165 and 166. That is the way. That means if you interpret state here as a state government, so explain the articles of the state government. Nothing wrong. Reason, the interpretation may differ from person to person. It is in the context of the government. So if you present according to central government, these articles will be enough. If you interpret according to the state government, then these set of articles will be sufficient enough in order to present the answer. And here, article 163, Council of Minister of the State headed by CM. Appointment of the council, 164. Business of the state will be conducted in the name of the governor, 165, and duty of the chief minister to inform the governor of a state, article number 166. However, there is a separate question in this same form at later part of this paper, I think question number 4. So there all these articles will be required to be explained. As a result, it is up to you whether you interpret in mandatory question for state or whether you may interpret this for the union government. That's why I have given you both the opinions so that at the time of exam we get this type of worry. So no need to worry if you have interpreted like as a state government. Then next one, question number 2. Okay. Now when we go for this question number 2, the first question is, Indian Prime Minister is more empowered than his British counterpart in the Westminster model of democracy. Elucidate. So, elucidate in general is about explain with example concept, or whichever the way you want to explain, you may utilize one or two examples in order to justify your opinion. And statement is a comparison between the Prime Minister of India and the Prime Minister of UK. That is the thought process. Now in this context, you may have to present this in two parts. Because it's a 20 marker, so we have to structure this answer. And in order to structure this answer, again, introduction part will be with respect to your parliamentary, that both the country have opted for the parliamentary democracy. As a result, in that context, real executive, nominal executive, that idea can be mentioned for the intro part. And then you may explain about the role or responsibility of the Prime Minister in the context of the parliamentary democracy. And when you are mentioning it, you may utilize the points. Let's say first part is for the similarity thing. What is that point? 1. PM as head of the government. PM as link between cabinet and nominal head. That dimension. PM to shape foreign policy. Is it? Then apart from this, we can even add here the PM as national leader. And PM to play the role for nation building. That way, 5 to 6 points in terms of similarity can be explained, one for India, and simultaneously it is better to use for the British Prime Minister as well, so that the answer will become lengthy. Reason, it's a 20 marker question, and for 20 marker we are going to fill approximately minimum 3 pages to 3.5, because space given in the exam is up to 4 pages. So leaving a completely page may be of no use. We have a content, so we should structure and elaborate accordingly. The more organized answers will definitely fetch a score. These days students are even making the diagram just to fill the page. More appropriately is what? When you have content, it is better to present in simultaneously points, so that more elaborate answers will appear, and show at least 5 to 6 dimensions, so that answer will appear elaborate. If only 1 point, 2 point you are explaining in very detailed manner just to fill the pages like it's in the colleges days are done, then that's not going to fetch a score. It is better to show 5 to 6 dimension for each and every Prime Minister, that is from India's perspective as well as the British perspective. In that way, you can present approximately 1.5 page just for this points. And then comes for some differences. When we go for the differences thing, then imagine the PM, that means it is in the context of the house to which the PM belong. Is it? So in Indian aspect, our PM can come from either of the house of the parliament, but there it is mandatory for directly elected members, that is House of Commons, and there only, that means the lower house of the British Parliament, the PM is supposed to be. In other words, the PM cannot belong to House of Lords. As a result, only the house where directly elected members are there, the PM should belong to that house. But what about India? In India, the PM can come from either house of the parliament. Plus, in order to be appointed as a PM, the person must be the member of the house. But in Indian aspect, the rule says what? Even if a person is not a member of parliament, still the person can be appointed as a prime minister. But within 6 months, the person has to become member of either house of the parliament. This is why empowering ideology, and the differences will be visualized in this way. Thereafter, another important thing, apart from this member of the house, there is also signing of bill. Signing of a bill is an important provision to show this difference. How come? It's called legal responsibility. What we study in India, collective responsibility and individual responsibility for the ministers. But in Britain, there is also a concept of legal responsibility of the minister. That means the bill which are drafted to make law are also signed by the ministers, and thereafter they approaches to the parliament for their approval, and thereafter the monarch will give the consent. In Indian aspect, the bills which are drafted are generally signed by the secretaries. Thereafter they went to the parliament for overall procedural formality, and thereafter to the President of India for final approval. In that context, this legal responsibility thing, signing of a bill, also becomes a point of difference between the Indian ministership and the British. Also, if the PM resign in UK, then in that circumstances, maybe the entire council of ministers may not go out of the office. Their ruling party will decide who will be their next leader, and he can be appointed as the prime minister. However, in India, we have a principle of swim and sink together, that prime minister is primus inter pares, which may not be applicable for that country. So in that aspect, you may utilize this idea for showing 4 to 5 differences between the two. And then we should also mention about nomination facility. We have a provision of nomination facility in the Rajya Sabha. In Britain, entire House of Lords will represent the privileged class or the different segment of the society which are the nominated by the crown. So in India, President will nominate, but the nomination will come on the aid and advice of the Council of Minister. And in this context, this point appears very unique for the Indian aspect, that is nomination in the Rajya Sabha. Point is same, how Indian PM is more empowered than his British counterpart in the Westminster system. And also we may remember the UK used to termed themselves as unitary form of government, and in Indian aspect we are a federal form of government. Because of this relationship of federal structure, the PM and CM, their participation in the Niti Aayog planning systems is also an extraordinary empowered mechanism to bring the coordination between center and state, which may not be applicable in this context of the British Prime Minister or Westminster's model. That way, our answer will be up to the mark and well structured answer in order to fetch a score. And remember, the question was elucidate. So with these relevant example, the answer will fetch a good score in the exam. Next one, B part. Post amendment period panchayats. Post amendment period panchayats have become a platform of competitive politics. Think competitive politics, but could not emerge as an agency of planning and service delivery. Examine. So we have to evaluate this particular statement. That means the question is about Panchayati Raj institutions, and that is 73rd Amendment Act. That's why the question is post-amendment period, panchayats have become a platform of competitive politics but could not emerge as an agency of planning and service delivery. So just divide it into two parts. Part 1, which is talking about the provisions plus their positive achievements. Is it? The provisions plus positive achievements of the Panchayati Raj institution as per 73rd Constitutional Amendment Act, which can be half part of this question. And second part will be focusing upon limitations which are faced by the local self-government or Panchayati Raj institutions. So two-way division of this question will help us to score an appropriate number of marks. When we are writing about this part, is it? In order to give an intro, you have a choice. One, it is better to use the term principle of subsidiarity. Otherwise, democratic decentralization. Is it? So we need to provide democratic decentralization as per provisions of Article 40 of the Indian Constitution, because that is the directive principles of the state policy. And more appropriately, the term subsidiarity, principle of subsidiarity says the functions of the government for day-to-day requirement of the general public, they should be performed at the lowest level of governance. And that's why the requirement of drinking water, hygiene, sanitation, road connectivity, street lighting, public places should be performed by the panchayats or municipalities. And those functions which may not be performed effectively by them, that means there could be inter-district movement, inter-district transportation. For that purpose, the function can be allocated to the higher level, that means state. And when it comes to national development, nation building, defense, bilateral relation, then those functions shall be confined towards the central government or union government. So it's a bottom-up approach which is advocated by the term principle of subsidiarity. Because it's a competition, everybody may not remember the principle of subsidiarity. We should remember. Reason, we have to fetch a score and we really have to score higher marks in this type of exam. So it is better to use the term principle of subsidiarity in the introduction part, and also mention DPSP article number 40, which talks about the local government as a subject and responsibility of your state government. And thereafter you go for the 73rd Amendment Act and the provisions like creation of a 3-tier structure, Gram Sabha, 29 functions, reservation for scheduled caste, scheduled tribe and women. Is it? Open competition by the political parties, political participation. That's why the political party symbols can be used by the contest of these panchayats or municipality level elections, isn't it? And this way we can present the first part of the statement that post amendment period panchayats have become platform for competitive politics. So competitive politics is representing this. Governments are taking initiative to establish panchayat. There are elections conducted for panchayat. Government is providing funds also to the panchayats. These all points can be in the first half, and in the second half we will come across the problems. When you are talking about problems, you may highlight that all the 29 functions are not given. 29 functions are not given to the local self-government by all states, which will be rejecting this idea about performances. Plus, the panchayat require funds. So, adequate funds are still a problem. And this may be due to the politicization of the system. This can be reflected by a term, lack of political will. That's a concept. That is a lack of political will, which is resulting into lack of devolution of functions to panchayat and resistance on devolution of funds also to the panchayats, which is a common criticism and a very generalized criticism. Let us add some technical criticism, and that is like activity mapping. This activity mapping is a division of responsibility about planning, resource mobilization, monitoring, and execution responsibility. Because panchayats are generally a three-tier structure: village level, intermediate level, and the district level. So which level planning is supposed to be done? Who will be responsible for the revenue generation or resource mobilization? Who will be responsible for implementation and monitoring plus evaluation of the panchayat plans? That's a concern. Plus, the Panchayati Raj Act is also supported by the Municipality Act, where one provision is in the 74th Amendment Act, and we should include it in the criticism part. Though it is not part of 73rd Amendment Act, but it is related to the combined working of panchayats and municipality. So you must use this idea of the term is District Planning Committee. I was writing the article first, 243 ZD. That talks about the District Planning Committee, which is not established by all the states, and it is adversely affecting the working of panchayat as a whole. Otherwise, entire urban area, rural area, which is part of the district, they should have a common developmental plan, but that is not taking place. Similarly, in some big cities, we have MPC concepts, 243 ZE. This is also not provided by various state governments. That means Metropolitan Planning Committee or Metropolitan Development Authority is also missing. And if it is missing, it will adversely affect the working of the urban and rural bodies together for the general public's welfare or overall facility provisions to the common people. And that's why that will become another criticism side for the working of local self-government. Plus, panchayat always have a challenge of trained workforce. The quality of the workforce is not up to the mark. And if quality of the workforce is not up to the mark, then imagine what happened to planning, what happened to thinking about resource mobilization. They all are going to be adversely affected, and these kind of points. Plus, one more challenge which is very common. What about the qualifications or quality of the panchayat members? That's also a criticism. That means the level of functional literacy is comparatively lesser in those parts. As a result, the awareness about policies program will be adversely affected, and that is reflected in the way how the planning are made at that level. People are not even aware. Identification of the beneficiaries is more and more politicized. The family members are given more priority to get the benefits of government policies. That means political patronage, political corruption. These kind of issues are adversely affecting the effective working of Panchayati Raj institution. And these can be the common criticisms we can use. These type of criticism we have covered in our classes under the topic local self-government, and even ARC reports have been used in order to highlight these challenges or problems. If it is urban government, then Niti Aayog document is also available, which we have covered for our class discussion to highlight the problems of urban local bodies. So these kind of way we can structure our answer for this question. Now moving on to the next C part. Former Chief Justice of India Deepak Mishra observed, an efficient judiciary is the hallmark of a great nation. Comment means he's simply talking about a statement about efficiency of the judiciary. So an efficient judiciary is for what purpose, and the question is just for 10 marker. Efficient judiciary is a hallmark of great nation. So when we are going to structure answer for this, we will start a simple intro, and that intro we may take from either the concept of separation of power supported by checks and balance. And because of this checks and balance, we get the concept of judicial control over executive and legislature both. Is it? And this is what amounts to the power called judicial review. That is the conceptual side for this type of question, that there is a separation of power among three organs, also supported by the concept of checks and balance, and because of this the power of judicial review arises, and this raises to the concept of judicial control over executive action and the law passed by the legislature. That is an idea to introduce this one. And then is the explanation part. An efficient judiciary is the hallmark. So in that context, we may have to provide positive points towards the judicial control. Means the judiciary can help to control executive or legislature overreach. That means if executive is going beyond their jurisdiction, judiciary can declare that law as unconstitutional. If legislature is making a law which is beyond the constitutional provision, then also it is the judiciary who can declare such law as unconstitutional. So judiciary can prevent overreach by executive as well as legislature. That is one dimension. Plus sometime executive and legislature, they have a delay. They do not make law, they postpone making of law, and that time also the judiciary can issue guidelines by using Article 142. Judiciary can issue directives in order to implement its order or any judgment or decree, and this is used by the judiciary in recent years. One, for resolution of the Ayodhya dispute, 5-acre piece of land said that it should also be given for the Waqf board so that they can also construct the mosque, and the disputed land side was allocated towards the Ramlala, and then this Shri Ram Janmabhoomi Tirth Kshetra thing is working in that regard. Second thing, current year there was a PIL in the court. It was about appointment of the election commissions, and in the absence of law by the parliament, finally the Supreme Court has decided a 3-member committee. Means executive is missing their power, legislature is not making a law, so ultimate responsibility is taken by the judiciary in the context of efficient judiciary. Plus with this efficient judiciary, we can also say that the judiciary can work in independent ways to protect people or people's right. These can be considered in the positive side for the support of judiciary. That means the judiciary can exercise judicial review to declare arbitrary action of executive and law passed by legislature as unconstitutional. Plus The judiciary can also issue guidelines in order to force the executive or legislature to perform certain function. Judiciary also have to protect the liberty or rights of the general public, and that is the traditional work which is assigned for the judiciary. And remember please, in the recent years, because government is taking more and more actions under its control under the philosophy of welfare state, so violations also got multiplied and it increases the responsibility upon the judiciary. These are all the positive side of efficient judiciary. However, the judicial control suffers from few challenges, and these few challenges can be, there is also possibilities of political influence. There can also be a challenges of personal biasness. There can be also the challenges of collegium system, which is often criticized by retired judges of the Supreme Court. That's why it raises a question, because some ex-CJI have also made criticism about this system. Justice A.K. Sikri and recently one ex-CJI, Justice Gogoi, who is now the Rajya Sabha member, he was also raising certain concerns about the judgment. But again, these are things said after retirement. When they are in the judiciary, they do not make attempt in order to bring the reform, but criticisms are genuine, so we may utilize them for structuring our answer. And then the judges also have their family safety is a concern which is used for informal pressure. Being a judge, I am also a human being. I also have a family, and if that is under the political threat or any security threat, it may simply influence my decision making in the working, or there are instances of corruption as well. Within the Delhi Tis Hazari Court judge, they have been booked by the CBI for the purpose of disproportionate asset cases. So disproportionate asset cases of the judges are even getting rise across the territory, but this is just one incident to understand the political corruption, that even there are instances of corrupt practices within the judicial system, and that amounts to violation of Prevention of Corruption Act. 4-5 points is sufficient enough in order to structure the criticism. Reason, it's a 10-marker question. So 4 to 5 positive points and 4 to 5 very briefly negative points, just to show a balance of the answer, because this is about the statement which is given that an efficient judiciary is the hallmark of a great nation. So if judiciary is independent, it can exercise its powers more appropriately, and it can protect the people who are dissenting the government. Means if I criticize the government, I should not be behind the bar. I'm not using an indecent language to criticize the government. I'm using an administrative language, a common layman's language, in order to criticize the government, and that should not be the ground for punishment. Even in one of the state of West Bengal in our country, when the High Court judge has made some observations about the state government, about some violence in the state election, panchayat election. So outside the High Court judge house, there were protests organized by the political party. This raises a question on the same point which I was using here. Family safety plus political influence and pressure upon that scenario, or sometimes political transfers are there. Means a judge who is making some comment, criticism about central government, they transferred from one high court to another high court. That type of incidents have came. Later on, it was clarified by that collegium took this decision early only, but again rumors got spread in the similar way. So we may not mention the name of a judge, but an example of a state that outside the High Court judge of a state of West Bengal, protest got organized, or a High Court judge of Delhi was transferred for making the comments about the central government over the issue. That way, anonymity will be maintained. No need to mention the name of the judge or the political party. That is more than sufficient to present the answer in neutral manner. Now, next question, question number 3. India has significantly advanced in its developmental goals increased efficiency in the public sector and unlocked innovation in public sector by adopting the approach of building digital public infrastructure. Elucidate. Is it? So again, explain with example concept is there, and the question is about digital public infrastructure. So in order to proceed towards this question, because it's a 20 marker question, the first of the thing to be required is what is digital public infrastructure? That is relevant. So introduction part will cover this concept, that what is digital public infrastructure. In other words, we can say this digital public infrastructure is the use of ICT, information and communication technology tools by government to provide e-governance or m-governance. Either of the way. E-governance is in the context of electronic governance. M-governance we can use in the context of mobile friendly services. These days there are so many applications developed by the government of India, and you can download those applications on your phone and can get the services from the government institutions or government machinery. So when you are using it for your mobile phones, you can even use this alternative term m-governance or mobile governance, which is just a utilization of a term in a context of the services done by the government. Then in that scenario, this entire system is about computerization, of the government institution. So this all started with National E-Governance Plan. During the first phase of this National E-Governance Plan, prior to that, even Atal Bihari Vajpayee government has also brought the 20-point program. Later on, National E-Governance, I think 12-point program, and later on National E-Governance Plan got modified by the successive government UPA. So no need to mention which government is bringing this, just mention Government of India. Government of India introduced this National E-Governance Plan for the computerization. And not just this, this computerization plus unique identity, that is your Aadhaar, that can also be channelized towards the general public. And present government under the Digital India has brought the linkage of Jan Dhan account, Aadhaar and mobile connectivity. These are all the examples in order to understand the elucidate part of the digital public infrastructure. So computerization of the systems plus connectivity of these computers with internet, or let's use the term high speed. This is done under Digital India. Computerization in the first phase, unique ID again in the first phase, and thereafter the present government started linking the Jan Dhan, Aadhaar and mobile number. So people can be provided the bank account, Jan Dhan Yojana, their Aadhaar can be linked, is it? And mobile number can be linked, because the mobiles are also expanding to the rural part because of this internet access expanded under the Digital India program from 2015 onwards. As a result, the term which we are using today, a Jan Trinity, is an outcome of these successive efforts. These are all the points which can help you to explain the application side of digital public infrastructure. Plus, after explanation of this, we may use one or two additional dimensions, and those additional dimensions can be what? One is COVID vaccination certificate. That is a very unique thing for us. That means you may have lost your paper document or anything. Just by your mobile number, Aadhaar connectivity, OTP, and you may simply re-access your certificates by this public digital infrastructure or digital public infrastructure. That is the positive side. And not just this, government have started implementing direct benefit transfer of subsidies or schemes. And in that context, multiple examples can be there. One, your LPG subsidy. Apart from this, pension, old age pension, widow pension, that type of direct benefit transfer schemes, they are all getting implemented under this way. Then apart from this, the Jan Dhan account, that means let's say use a term loan, Swanidhi, is it? Then this one, there is a scheme for PM Kisan, 6,000 rupee one, etc. This way, the central government have done these type of reform. Similarly, certain state governments, they are also using this type of platform by their state investments or by their state infrastructure, and as a result, the welfare schemes, that is pension schemes by the state government, they are also getting implemented in a similar manner. The health insurance by the state government, it's also getting implemented in the same way. And state government with respect to education scholarships are also getting implemented in a similar manner. So we may have list of examples. We may use 2, 3 in order to show the dimension. Reason, it's a question which require elucidation. So 3, 4 different examples can help you to structure your answer more appropriately. And at the last, it is equally important to provide its advantages side and few possible challenges. In that context, we can say this digital services are providing greater transparency, target beneficiary, reducing corruption, is it? Greater transparency, target beneficiary, reducing corruption, and greater access to public plus facility from doorstep. All positive sides. All positive sides. But still there are possibilities of challenges, and challenges can be what? Digital divide. That means haves and have-nots concepts. That's a challenge. Plus functional literacy. That means if somebody wanted to even use functional literacy, that is low levels of functional literacy. And also it's about exploitation because of lack of literacy, lack of functional literacy. This type of idea as a criticism can be used. Plus in certain parts, if the internet speeds are not up to the mark or digital backup is not there, they will again remain deprived of the system. So government is trying its level best to reach to the larger and last mile connectivity. but still implementation challenges results because of the bureaucratic approaches, sometimes due to lack of coordination between the central and state government, and as a result politicization of the situation is also one of the reasons we can use. Politicization and lack of coordination between center and state. These can be used as a criticisms in order to make a point against the digital public infrastructure system. However, largely it is positive, but we have to balance an opinion. So few limitations which are practically possible limitation are to be highlighted in order to make a complete balance answer. Going to the next question, question number B. Attempts to prepare unified and holistic plans for the country are complex and full of challenges. Discuss. So the question is about planning, is it? And planning from unified manner. Let me just go back to this. It's a question number we are discussing is 3B. Yes. So this is with respect to the planning. Is it? Attempts to prepare unified and holistic plan. So the key word to remember is unified plus holistic. Are complex and full of challenges. Discuss. So question is about discuss. So both positive evaluation and negative evaluation we have to go. So in order to approach to this paper, crack this code, unified and holy. It's about piousness, or it's about a thing which is acceptable to all. That is the concern. So holistic is one which is available and acceptable to all. In that context, this question is about centralized planning and its possible advantages and the challenges. To structure this answer, because it's a 20 marker, we will start from one concept of planning and the need for planning. मतलब क्यों चाहिए? That's an idea. So planning is a process under which we determine some goals for the nation building, social development, and then we will achieve these goals in a systematic manner. That process is termed as planning. So we may assess our resources, we may identify our problem area, and then accordingly we will think about a solution to resolve the problem. So this process from identifying problem to resolution of the problem will be done through a process called planning. So planning is a process of determining goals and identifying the means to achieve those goals, and after the achievement of those goals, evaluation of the process is equally important. That process can be termed as the planning. So why you need planning? You need planning for certain reasons. Reasons can be what? The planning will provide you direction. We are a federal country, center and state should move in a particular direction. So that direction can come from the planning. Plus, planning can also reduce risk of uncertainty. Is it? We may have so many uncertainties about the future, but if we have a plan, we may face those uncertainty with a predetermined policy objectives. As a result, planning can be useful in that regard. Plus, planning can also help to avoid overlapping and wastage. central government, state government make policy on a same plan, same issues. Let's say agriculture is a state subject and center also have Ministry of Agriculture. So if both will make separate policies for agriculture, it amounts to overlapping. It is better they both can join hands and some sort of centrally sponsored schemes can be provided. Or if states are implementing this policy more appropriately, center shall not interfere into that scenario and may work for some other ideas. This overlapping wastage of resources can be resolved with the help of the concept of planning. That's why in this answer we initially require why planning or what is the need for the planning. 3 dimensions are there. Plus planning provides rational decision making. This is also equally important. Rational decision making means we are not taking decision only just for the political reasons, but we are taking the decision on the basis of the problems which are faced by our country, the resources which are lacking at the center or state level, and for that we are making a plan. These kind of ideas will be suitable to initiate the introduction part and brief explanation about why we require planning. Once we complete this discussion, thereafter we will proceed to the second part of this question, and there we will focus upon centralized planning in order to show unified plan. That's an idea. That means the planning process can be centralized. And in this context, do remember we are a federal country. So this federal country idea of centralized planning can be in two ways applied. One, when center is going to make plan for all states. That is one form of centralized planning. And second, when state is going to make plan for all district within the state, that is the second type of centralized planning which also exists at the state level. Because most of the time as a student we just only focus upon this side, that center is making a plan for the entire country and only that is centralized planning. That is correct, but also you need to remember the dimension of your own federal structure of the country. And because of this, when the state government or state planning board is making plan for all the district as a whole without including their ideas or suggestion, will also be reflection of a centralized planning at state level. And in these kind of centralized planning, there are advantages plus limitations. So think about four-way division of this entire answer. Initial one, page 1 of our answer, we will go with the what is planning and what is the need of planning. Next part, we will go for the concept of centralized planning and explaining that in our country, this centralized planning may exist at union government level as well as state government level, and we can explain this part. And thereafter we will go for examine part, and in the examine part, advantages of centralized planning and disadvantages of centralized planning. The way we will structure this way, it's definitely going to help us to fetch a good score in this competitive examination. Now the next one, because centralized planning is a very common topic under plans and priorities unit, and it's a straightforward advantages disadvantages point which can be added. Moving on to the next part, question number 3C. Excessive political interference in the development process has become cause of concern in achieving national goals. So question is about political interference and that is going to affect what? National goals. So there are certain national goals which are established or determined by whom? National goals will be determined by your central level agency. In that regard, you in the present time period, if I use Niti Aayog brought the idea of vision document, which is a 15-year plan for establishing our national goals. In order to achieve these national goals enshrined there, we are running multiple programs in the context of road connectivity, rail connectivity, housing, employment generation, skill development, health. Multiple aspects are there, and in that context, these policies are coming from center. So number of times central government comes with the term is core schemes and core of the core schemes. We know these by another alternative term, that is called centrally sponsored schemes. Is it? So most common term is this centrally sponsored schemes, but they are now also classified as core schemes and core of the core schemes. So in this regard, the central government is formulating these policies and asking the states to participate and implement for the purpose of national growth or national goal. Both the way, growth is economic aspect and goal can be for social welfare, upliftment of the poverty ridden section of the society. That is why skill development is needed, that is why housing is needed, employment generation is needing. So in that aspect, overall national goals are to be implemented. But we are also observing that in certain states, the state government may belong to different political party and central government is from different political party. So just because of the political reasons, the states, what they do, the states refuse to implement or participate in the scheme. This is one common problem these days is existing. Think about a scheme called PMJAY, popularly known as Ayushman Bharat. So when it was introduced, initially the Delhi government, Punjab government, Rajasthan government, they refused to participate in its implementation. And issue is only about the political obstacles. PM Kisan was introduced in the country and West Bengal government refused to participate, that it's just a publicity stunt by the central government and we will not participate. But these examples are relevant because question is about political interference. And not just this, number of time in the developmental plans, due to political interference, the projects, they are allocated to companies which may not have the good standing, and there are possibilities of political favoritism in the plan location. There is a compromise with the quality of the project, like in fact the current year only, the current year in which we are right now, we have seen one demolition of under construction bridge in the state of Bihar, which was getting developed on the river from last few years. So who will pay for those losses of hundreds of crore rupees of the taxpayers' money, because it's an infrastructure project and was important to connect two sides of the river because it's a main river in the Bihar, and the development project was finally demolished, and it will now require more resources because cost of construction in the last 5 years and in the next 5 years is going to be a huge mismatch, and whatever money we have spent for the construction will go out, and that will reflect what projects are allocated to the company which may or may not have the experience, and due to political patronage the projects are allocated. That's one of the common problem. Even one example which is very negative in the current scenario, this Cricket World Cup is going to be there in the country, and the telecast rights for the Cricket World Cup have been given to an app which is Reliance Jio. So they may not even have a sports channel. There are so many sports channels in the country. DD Sports have been there as the national carrier. They will get it free of cost because of its position. But Star Sports, ESPN and the 10 Sports, multiple sports channels are participating. But despite all this, the allocation rights have gone for the company. And when they actually run their app, it has so many technical snags. That means the app got blocked, the app got slow, maybe the internet speed is up to the mark, but the app is not responding properly, is going to raise a question about quality of work. That's a bigger concern. Quality of work is a challenge, and that can simply be identified on that scenario. Otherwise, various apps which are coming from other companies, maybe it is about the Star Sports app, that is the Hotstar or any another one, they all have subscription plans. You make a payment and you will rarely find any technical snags. But here means you even pay for this app or it is free of cost, both the way available, but in both the way it is working in a very dissatisfactory manner and raising a question about quality of the work. Similarly, there are also possibility that why the politics participate, it's you can say political publicity. This is also becoming an issue. Air quality control in the Delhi is a challenge every year. So here our Delhi government also made some smog towers. 2 only have been made, but we have spent more money on their politicization or their publicity. And maybe suppose 20 crore is the construction project and 20 crore we have spent on the advertisement. So in that much money we may spend even and construct 2 smog tower, and they can cover double area, and also the people will feel and will provide the good feedback to your good work, but we are spending money in such a way for the political publicity, and that is even taking place at center as well as state level, and this is negative. It is a part of excessive political interference in the national goals, because these days extra money is allocated for advertisement campaigns in the name of public awareness, and the public awareness campaign ads usually propagate the minister, that could be the chief minister or the prime minister, for their political image making, which actually defeats the idea of national goal or limited funding for expenditure of goal achievement. That way this criticism can be utilized. So it's a 10 marker question. We do not require so many of the detail, just 1 or 2 example will be sufficient enough, and thereafter these criticisms, 4-5 points of the criticism will be sufficient in this answer. Next question, 4a. There shall be a council of minister with chief minister at the head to aid and advise the governor in the exercise of his function, except, after that is the dots, that means except when the governor is to act in his own discretion. Actually that is the complete statement from article number 163. This constitutional provision is being intensively debated nowadays. Elucidate, that means explain with example. So here the first part is about constitutional provisions, and with that context article number 153, 154, 163, 164, 165 and 166. These all constitutional provisions are relevant in this type of answer. 1. there shall be governor of state. 154, executive power of state. 163, council of minister to aid and advise. 164, appointment and responsibility of council of minister. 165, it is conduct of business. 1 small mistake, it is 166 and this is 167. And this 167 is duty of chief minister to inform. Duty of the chief minister to inform the governor of the state. These are all the constitutional provision which can regulate the relationship between governor and the council of minister. In this regard, these articles are in recent years with few controversies. The few controversies we will find, one was in the state of Tamil Nadu. Another one was in the state of Kerala. Two, southern state where two major controversies have came out between the governor's office and the minister's office. Because example is, the question is elucidate. So rather than writing name of governor, just use the term Kerala governor and Kerala minister, Tamil Nadu governor and Tamil Nadu minister. And one more criticism which has came, it was in the Maharashtra. Three examples are there, maybe even two will be sufficient in order to mention in your answer. And according to this, in the state of Tamil Nadu, the state government has drafted a bill and they were looking for exemption from the NEET examination which has been launched by the central government for the medical means education, graduation and post-graduation level. And the state government is of the view that we shall be exempted. So state government drafted a bill. So bill draft is the state responsibility. State assembly has passed the bill and after that the bill was referred to the Tamil Nadu governor for his approval. Now the governor here has power which come from article 200 and 201. Governor may give assent to the bill, governor may reserve the bill, that is withholding of a bill, that is both coming from article number 200, and governor may send the bill for reconsideration of the state assembly once. All these three power come from article 200. So when the bill made by the state government, it has overlapping with the subject on which central government already have a law. So ideally the governor may reserve the bill for consideration of president. That means use article 201 and refer that bill for consideration of the president. If that way it is done, it is also an ideal condition. Second, governor can also utilize his discretion and may use article number 200 and by using article 200 can withhold the bill. So I am declaring I am withholding my bill and the bill is coming in the definition of the pocket veto. After that, neither the bill will be passed nor the bill is going to be lapsed and the bill will remain with the governor of the state and it is not going to become an act. This is one of the incident of clash between the Tamil Nadu governor and the Tamil Nadu government where these advices are not getting followed and the governor is using his own discretion because that word is except where he has to act in his own discretion. So that discretion may come from various other articles of the constitution rather than just 163. Second thing, Kerala governor. So in the state of Kerala, the Kerala government was passing a law and they were excluding the governor of the Kerala as chancellor of university. Usually what we study that the president is the chancellor of all the central universities, governor is the chancellor of all the state universities. So that university will work different from the government and they will work in an autonomous manner and should not be the institution of politicization. That's an ideal condition. So Kerala governor has restricted the bill from approval, and the minister in the Kerala State Council of Minister was making some derogatory remark against the Kerala governor, and that has been made on a public platform. So governor of the Kerala said, I am withdrawing my pleasure from the minister. That means the ministers hold office during pleasure of the governor from Article 164, and the governor is saying that I am withdrawing my pleasure. So there is no such provision in which the governor can withdraw the pleasure by using his discretion. The governor may remove a minister from the office if the council of minister advises or chief minister advises to remove that minister. But this is how the controversies arises in the country, and the misuse of the provision are used, or we can say abuse of the provision is also made in order to make this politicization of a governance structure. So in this regard, Kerala governor is not correct, but Kerala minister is also not correct. What statement he is making derogatory against a constitutional body are derogatory in nature, and they should prevent such type of behavior. They should also follow ethical behavior as recommended by 2nd ARC ethical conduct or code of conduct for the minister. That can make it more appropriate. And third example, which is in the Maharashtra. So Maharashtra government has an aeroplane. Maharashtra governor was to go for an official purpose at Labasna for civil services academy training institutions, and it was technically a kind of official visit, so it's like a state visiting, and the state government, they refused to provide the state plane for his journey, and they said we were having no information and no awareness, and they refused to provide the plane. No clearances were given, and he traveled by the private flight. This thing is also reflection of a abuse of authority, and these are preventable things, because you are making a misuse and creating politicization of a matter, and it was during the time period of Mahavikas Aghadi government against the governor of their own state. So point is, these are state property. They are not the personal property of the chief minister or personal property of a governor. If it's an official visit, so for official visit, the state is supposed to provide the state apparatus or state machinery for their official transportation. Otherwise, it will become highly politicized matter, and it is a disrespect also to the constitutional body. And this is one of the reasons why the governors of the state are often criticized as spy of center, agent of the center. But point is, if I'm doing my constitutional obligations, I'm not making a misuse of authority. If I make a misuse of authority, I can attract a criticism for my office. But if I'm doing the thing as per Supreme Court guidelines, Supreme Court direction, then I'm doing the things in a fair and transparent manner. Plus, this point can also be used for one more, and that is about appointment of chief minister in case of hung assembly. This is also a discretion which can come upon the governor in case of hung assembly. So rule says single largest party. So if I am appointing the person from single largest party as a governor, as the chief minister, being a governor, I am appointing the chief minister from single largest party. So I am not violating the constitutional provision. Is it? I am not an agent in that regard. But if I call second largest party, third largest party, then definitely possibilities of biasness can be visible. So if a governor is using the single largest party for appointment, or they fail to form the government, then I will give the chance to second largest, third largest. That is the sequence I have to follow as per the Supreme Court's judgment with respect to appointment of the chief minister in case of hung assembly. Otherwise, if I am directly jumping to second, third largest party and there is no pre-poll alliance, then I may be violating my, maybe misusing my governor's position and working on the behalf of the central government's directions, which is a wrong approach, and subject to criticism. These dimensions can be used to structure this answer because there are multiple explanations have been there. Question was elucidate, so no such critical evaluation may be required, and just sufficient number of examples will be enough for this type of question. Moving on to the next 4B. There is a need to redefine and realign the functions of the deputy commissioner or district collector. Elaborate. 20 marker question. So this is a very common question every year on the office of district collector, and to approach this question we will divide it into two parts. First part, we will mention about functions of district collector. So 8 to 10 points will be enough to mention on 1.5 to maximum 2 pages with respect to the functions of district collector. Like he is responsible for law and order administration, mention about it, responsible for revenue administration or tax collection, that is excise and other, mention about it, responsible for welfare function, so various welfare programs are coordinated with the help of DC, mention 1 or 2 example for this. He is responsible to conduct elections for center, state, local cell government within the district because he is a district electoral officer, so that could also be a function. He is also responsible for disaster management in the district because district disaster management authority work under his leadership. Plus he is also responsible to empower panchayats and approve the panchayat plans, is it? So execution of those panchayat plan, implementation of the panchayat plan will be done with the help of the office of district collector, that is another function. Plus he is responsible for licensing, arms license, theatre license, fire license, various types of regulations are done through the office of the district collector, which can be another considered function for this office. And he is supposed to provide connectivity between civil society in the district and the common people or the government machinery. So some outsourcing of the policies and program are concerned, for them also he will play this role. So 8 to 10 different functions can be explained in the first part for office of district collector. And then come on the second side, there is a need to redefine and align the functions of DC, and for that second part we will use the recommendations of ARC. Second, which has suggested that yes, there is a need to realign the functions of district collector in accordance with the contemporary time periods, because now the challenges are growing. That means there are instances of MNCs approaching to the different parts of the country. So district collectors are also supposed to regulate, monitor their working and ensure the quality standards are followed there. So he and his office needs to be upgraded in that regard. Not just this, even there is an extension of RTI, citizen charter, applicable for various organizations in the district. Plus it is equally important that you may provide the concept of district government supported by district council. This is even recommended by the second ARC, and according to this it is suggested that there should be concept of district government. How? We have panchayats, we have municipalities, so they are common in a district, so you should have a concept of district government, and that district government shall be supported by the district collector, who will play dual role, assistance in the policy formulation and thereafter line function, that is implementation of those plans and policies. In this way he will function like a chief secretary to the state, so he will be working at the district government level, and this is also recommendation. Plus there are some sensitive districts in the sense it could be left wing affected district, could be terror affected areas, could be the areas of disturbed area category. In that regard, you need to provide appointment of a DC who have at least 8 to 10 years of experience. That means a new recruit may be avoided and give an experienced officer to those area so that effective working can be organized. These are major recommendations given by the second ARC for this office. And most important, technological upgradation. So computerization, access of all the resources at his office, single window cell for his office, these are all with respect to the technological upgradation can also be added as recommended by the second ARC. It was a direct question, it's like a regular question which comes almost every year in just a minor modified form. This year also it has been in a similar way and a straightforward statement was given. That is more than enough because the question was elaborate, and elaborate is all about explanation. And the last part of 4C, examine project Bharatmala Road to Prosperity launched in 2017. So a direct question. So this is application of current affairs in public administration, is it? And means ideally this question can be in paper 1 under the unit public policy. That is the ideal way. But these years lot of things are done. The question may be of different paper but asked in a different paper. So that does not adversely affect its answer writing. Answer will remain similar. And the condition is the Bharatmala project is for road infrastructure. And what we should do, we should briefly add the features of the Bharatmala project, because the question is examine the project Bharatmala Road to Prosperity launched in 2017. So in this simple thought process, what we will do, we will explain that this Road to Bharatmala project is advocating construction of corridors. What type of corridors? Economic corridor. Plus it is even advocating inter-corridor and feeder routes. Then it is also talking about national corridor, coastal and port connectivity road, thereafter it is even talking about Greenfield Expressway, and also one last, that is border roads or border road connectivity. So technically 6 components exist for this Bharatmala project, and if it is implemented, then please remember from 6 corridors we are going to expand it for 50 corridors. That means we are creating a network of roads. Coastal area, there we can connect. We may have a dedicated rail freight corridor. So rail freight corridor is by the railway, but from those railway corridors, we require connectivity to the city, urban town, rural area. For that part, every district will have a minimum 4-lane highway. Every district will have a minimum 4-lane highway as per this Bharatmala project. That's why the statement is road to prosperity. So once we mention just a brief component of this in the first part, thereafter we may tell about the positivities, means what will be the benefit of infrastructure connectivity. There will be faster movement of labor, faster movement of goods, employment opportunities will be created, and not just that, even industrial growth can also come. If industrial growth is coming, overall standards of living will gradually improve. That's the reason why Bharatmala is a road to prosperity. These are the points which we can use in order to examine that statement. Bharatmala launched in 2017, Cabinet has approved it, proposed by Public Investment Board, approved by Cabinet Committee on Economic Affairs. Being a public student, we should add these two lines. Proposed by Public Investment Board, approved by that is Cabinet Committee on Economic Affairs, and thereafter just 6 components can be mentioned and point about positivities, that it can lead to employment generation, better infrastructure connectivity, faster movement of goods, faster movement of labor, employment generation, new avenues for industrialization, balanced regional growth, will reduce migration to the metropolitan city, and new urban areas will also get developed. That way this answer can be completed. Right? Now we'll be moving on to the next question. Now let us move on to the section B part, and there question number 5A. So this question is about, it's again a direct question, the district training component of induction training of IAS officer requires to be revisited, examined. Means in the section A there was a question about complete role of the district administrator. Here this is about the induction training, because at the first stage of our career, when this foundation course training is done, then 1 year district training is provided. So the question is about, is there need to re-examine? So point is, already government have updated National Training Policy 2012, and according to this, the district training program will be focusing upon your initial challenges. That's why the training is given under the control of a district collector to learn electoral system, how to conduct electoral duty, maintenance of law and order, and the IAS officer attached with multiple offices in the initial years. Reason, wanted to acquire you the understanding of the entire administration. Plus the language training from the state wherever we are posted will also get imparted during that time period. Reason, communication and linguistic challenges can also be sorted out. So just briefly mention what are the components of induction stage of training. This question is with the respect of civil services in India. From their induction training program, that components can be explained. So it is about, the objective will be on maintenance of law and order, revenue administration, electoral duties, awareness about local laws and customs. Is it? What are the various laws, customs existing in the state? About that, this awareness is supposed to be there. And also the licensing in the state, that is regulatory functions, and disaster management. 4-5 dimensions will be included in this answer, as it's just a 10-mark question, and the major focus is upon the induction stage of training. And once this induction training is completed, after that the candidates, they used to again go back to their training institution for presentation, experience sharing, and also the debate discussions are organized at the phase 2 of the training program, and thereafter the training get complete for the final posting. So it's already been revised in 2012. So you briefly may explain the components, that what are the different type of focus is given upon the field training or district training of the civil servants. That will be more than sufficient in order to present this answer. Going on to the next part, which is 5B. Mission Antyodaya strives to realize the vision of the poverty-free India. Examine. So basically, this statement is the goal of Mission Antyodaya. Mission Antyodaya has been introduced in 2017-18 budget. This is basically the third question on the scheme or program in our paper 2 puppet. That means now the paper is demanding more and more application based understanding, and which is good also for us. By reading this way, we will be developing a problem solving attitude, and after our selection, this thing will help us in long run to work as a very good administrator in comparison to any other optional subjects coverage. That means it's helping us to develop and think like an administrator from the days of even examination itself. Now, this part, which is Mission Antyodaya. So, this Antyodaya mission is demanding from us that it's initiated in 2017-18, and the question is about examine. So, what we should include in this case, that the project was introduced in 2017-18, a very brief intro, and what are the components. So components are like, there will be coverage with the help of local bodies, plus it will be focusing upon the basic amenities in order to improve the livelihood, access to home, is it? So homeless population, some Manrega related job employment opportunity, technical advancement, we can provide these things also with the help of Panchayat's identification. And this Mission Antyodaya will be focusing upon Gram Panchayat development plan. So Gram or village Panchayat development program. That means the focus is upon targeting the lowest strata of the society. So in each village, survey, and this is annual survey. Annual survey will be conducted, information would be gathered from Panchayat level, and those who are living in the extreme poverty, means homeless population and no access to the job or employment opportunity, landless population, they will be targeted first. And that is why that focus is on Gram Panchayat development plan and will be executed with the help of the Panchayat. So from center to states and via state participation to the local self-government, that is the idea of this Mission Antyodaya. And if it is properly implemented, then definitely it will help us to go and achieve poverty-free India. Because PM Awas Yojana will be implemented with this, gas connection will be implemented. Not just that, even employment generation, skill development, combination of them will be executed by identification of Gram Panchayat Development Fund. That's why this is an initiative in a right direction to achieve even the United Nations goal also, which are in the category of the Sustainable Development Goals, SDGs. So we may achieve those SDGs also in synchronization with our Mission Antyodaya. That is the idea which we can present in this answer. Going to the next, dynamics of coalition vary with the nature of leadership, political parties and contemporary political conditions analyzed. So it's a question about coalition politics and its impact upon the leadership. And this is true at all the levels, your union level, your state level and your local self-government level. Anywhere you apply this logic of your understanding, and what it simply says, in terms of portfolio distribution, in terms of any strong decision, in terms of disciplinary action, two, three dimension, because it's a 10 marker question. So accordingly, at union, state or local self-government level, we may apply this understanding that these dimension, if you have a clear-cut majority, your prime minister or your chief minister can decide who can be given which portfolio. But when you have a coalition government, your power to decide which ministry will be headed by whom will get adversely affected, and that will be dominated by bargaining culture. Strong decisions, they are delayed. Means we wanted to end subsidy. We wanted to end old pension scheme and replace it by the new pension scheme. But our coalition partner may not allow. And as a result, our coalition politics may result into such type of misuse of a power or authority. Disciplinary action, maybe there are people indulge, political leaders indulge in the corrupt practices, corruption charges are pending, criminal cases are pending, but we have a pressure, political pressure with our coalition partner not to take an action, and it results into delay in those actions. These are all the different consequences which can come because of the coalition politics. Not just that, coalition politics also seeks to promote vote bank politics. As a result, maybe encroachment on the public land, illegal growth, channelization of illegal drug rackets, that all, no action will be taken against them, and they simultaneously keep on dominating within the system. And these are all negative side of the coalition politics which needs to be highlighted. However, coalition politics may have one or two advantages, and those one or two advantages is the coalition politics is more accommodative. It may also helps regional aspirations. That's also important to highlight for the coalition politics. It's not everything is bad. There are also possible positive things also, and it's like otherwise what will happen? Single party clear-cut majority, domination of one group may happen, majoritarianism may happen. So if you require more accommodative policies, then that is the positive side, accommodative politics. Plus, maybe if the government is formed by the leader from just 4-5 states only at the central government level, you'll find all the policies will favor only those states. But if there is the regional aspirations to be solved, then coalition politics can play this positive role for regional aspirations to be resolved through central government system. Same is applicable at the state level, and that's why the coalition politics has its own pros and cons, and question was about analyze. So point positive as well as negative both can be presented in the answer. Moving on to the next question, 5D. Computerization of treasuries has revolutionized the accounting and budget planning process. We have used already a question earlier, digital public infrastructure. So here they are just directly talking about the concept of e-governance and restricting it to the concept of budget planning. So this budget, Ministry of Finance, taking the estimates from all the ministries and departments of Government of India, and also seeking the central assistance to state plan from state governments in order to provide the financial assistance. and that way this entire budget formulation is done in a limited time, and also the execution can be monitored. In this context, we may also add name of one scheme, Public Finance Management System. Government has introduced Public Finance Management System under this computerization program of the ministries and departments, and that Public Finance Management system is exclusively with the Ministry of Finance, and that helps them in order to get estimates and also for disbursal of the money to various ministries and departments. Even direct benefit transfers are also covered by this Public Finance Management System. So it's a direct question with respect to use of e-governance in the process of budget making and budget execution. So in terms of componenting, Public Finance Management System can be briefly included in order to explain this answer. Because the question was comment, so answer is yes, it is true. There is a revolution in the budget making and budget execution because everything can be tracked, monitoring can be done instantly, data record management can also have been improved, and immediately the tracking can be done. Plus, due to adoption of technology, DBT is also working more appropriately, and even if there are centrally sponsored schemes, so how much money disbursed to the state, how much money utilized by the state, that data are also updated now on monthly basis. This is the reason why there will be revolution in the budget making as well as budget execution, and the statement is completely correct. We require to support this statement. Next one, do you agree that code of ethics and code of conduct for the ministers would help in upholding higher standards of constitutional and ethical conduct? Explain. So this is a direct question about, there has been recommendation by the second ARC that there should be code of conduct and code of ethics for the ministers also. So the question is, do you think that it will help? So yes, we think that there should be code of conduct and code of ethics. So these ethics are like norms, and this code of conduct will guide their behavior. Means, let's say, impartiality. Is it? So code is like impartiality. So the minister should not seek benefit for his friends and family members in order to maintain impartiality. That is a straightforward idea. Professionalism. So maybe code can be professionalism. So the minister should not issue any informal direction. That's a straightforward idea. Or there are ministers who may have the conflict of interest. Conflict of interest in the sense, maybe I'm a member of parliament, also a minister, and I'm having some educational university in my name. And there's a discussion going on in the parliament on education. So in those circumstances, I may have a conflict of interest, so I may not participate in the parliamentary committee which is dealing with the matters of education, and that is prescribed in the code of conduct by the second ARC. Plus there should be code ethics commissioner should be there in the parliament, and they should maintain the register that which member has in conflict on which particular matter, so that when the parliamentary committees are appointed, these ministers, or ministers are generally not the member, but the members of parliament should also not be participating in case if they have a conflict of interest, so that more appropriate discussion can happen in the committee and more neutral, more impartial and larger public interest can be protected. That is the reason why we will support this statement that yes, I support this idea that there should be code of conduct and code of ethics for the ministers, and it should be developed on the lines of civil service conduct rules. In fact, there should be code of conduct for the judiciary also on the lines of the code of conduct for the civil servants, so that all the three, executive, legislature and judiciary, will have ethical code in order to guide their behavior and conduct in the ministries or department or discharging their duties and functions. So that way we will support this statement. That is all for question number 5. Next one, question number 6. Question number 6 is also a section A, is a direct one. Civil service reforms along with transparent transfer policy will go a long way in insulating civil servants from undesired political pulls and pressures. Discuss. So idea is about overall civil service reforms. That is the major part, civil service reforms, plus the idea of transfer policy. So transfer policy is a tail, major part is upon civil service reforms. As a result, you may use here recommendations of your second ARC given in the 10th report on personnel administration. That will help us to structure the body of this answer. Civil service reforms related recommendation. That means we may have to think about recruitment system, age of entry, because they have recommended 25 to 26 years, 25 to 20, maximum 9 years in case of the scheduled caste and scheduled tribe, and number of attempts also to be restricted from unlimited to maximum just 6 attempts for the member of scheduled caste and scheduled tribe, and for OBC can be 5 attempts, and for general just 3 attempts have been advocated. That's a part of this recommendation. Recruitment, age of training, entry, training thing. Training is what you call capacity building, that is required, plus domain expertise. That means you can acquire the education at later on stage after selection also to improve your quality or capacity as a civil servant, and there shall be no promotion without training. Before you are going to be promoted, you have to undergo the training program to improve and upgrade your knowledge and skills, and thereafter the training can be, the promotion can be provided. Plus, we can also give promotion from state to All India services. So for them it was recommended a conduct of examination should be there to identify the eligible people, and they should be less than 40 years of age so that they can contribute for the next 15-20 years for the central government. If from the state services you are promoting somebody at an age of 50, 55, that person is looking towards his retirement. So rather than an asset to the All India service, that officer may become a burden upon the All India service. And in this regard, the Veerappa Moily Commission or second ARC, they recommended that the person should be of less than 40 years of age and at least 8 to 10 years of service experience in the state services. That means somebody got selected in the state service around 25-26 years of age. So by 40, the person may have 10-15 years of experience and he can be most eligible person for the promotion. This is the idea. That's why these are all the multiple civil service reforms which can be used. And then comes the transfer policy. So for the transfer policy, you may use the term tenure of office. On one position, there should be a tenure of 2 years to 3 years shall be provided by the state government. And if you violate rules, regulation, then as a disciplinary measure, the transfer may happen. Otherwise, we may be provided a fixed tenure. That's an idea. This is what this question is demanding in order to present the answer. So these are all the recommendations from the second ARC, and the transfer policy is with respect to the fixed tenure, and the officer can be transferred before the expiry of the fixed tenure under some special circumstances, and the officer should be given a reasonable opportunity of being heard. That means principle of natural justice has to be followed. That is an idea. Thereafter, the next question, 6b, and this is very overlapping question between the pub-ed and the security topic, and this is about Armed Force Special Powers Act. So the question is, the withdrawal of the Armed Force Special Power Act from Tripura has sent a positive signal across the state and northeastern region. Do you think that now it is the appropriate time to take more rational policy decision in this matter? So divide this into two parts. One part, conceptual side. For conceptual side, what you require is the concept of disturbed area. Who can declare an area as disturbed area? So this power is now with the president as well as governor of a state. Both have a power under the Armed Force Special Powers Act to declare an area as a disturbed area. So central government can also declare, so as the governor will recommend to declare the disturbed area, and then Armed Force Special Power Act can be implemented. And thereafter, what are the extra power with commanding officers? That's a concern. That means they do have a power of search any premises. They can enter into any premises without any search warrants. On the grounds of suspicion, they do have a power for even shoot. Shoot at sight options means they are asking the vehicle to stop and not following their direction. They do have a power to even causing injury, even up to death in those cases. And they enjoy immunity under the Special Powers Act. Plus, they can even destroy any place where it is used as a terror hideout or used for the purpose of dumping the weapons or any sovereign activities. That is the idea which exists for this system. That means these are provision side which is going to represent your concept. And then comes upon the second side, means because of these type of provisions, there has been criticisms. Criticisms, these are about abuse of power. Killing of innocents. These are all allegations which have came against the Armed Force Special Powers Act. Plus, one of the human rights activists should be referred here, Iram Sharmila. She was on fast unto death for approximately 15 years in order to demand the withdrawal of the armed force from her state. Means though it's recently withdrawn from the Tripura, but the overall idea is rational policy decision in that regard. So just cannot restrict only to Tripura. Entire Northeast is under the Armed Force Special Powers Act, and since 2014-15, the current government is taking up certain initiative to reduce the enforcement of this Armed Force Special Powers Act. Plus, apart from this abuse of the thing, in the past there has been a committee, Justice Jeevan Reddy Committee. It was way back in 2004-5. This committee has made recommendation for repeal Armed Force Special Powers Act from Northeastern region. That was way back in 2005. Recommendations have came. I'm using just a financial year for that purpose, but in 2005 that recommendation have came. Committee appointed in 2004. Recommendation came in 2005. That's why both the years are included. And that committee, which is headed by a justice, it recommended repeal or withdraw Armed Force Special Powers Act. And in the recent years, the current government, they are signing peace agreement with the Naga Peace Accord and various other regional groups in the entire Northeast, state by state. And that is why they are withdrawing this Armed Force Special Powers Act provision, as mentioned, Tripura. And that's why the question, do you think it's a rational thing to do for other? And yes, it is rational to do, because in the Assam also, the 8 districts are under the Armed Force Special Powers Act, and by 30th September this duration will get over, and Assam CM is already making the statements and asking the center to withdraw Armed Force Special Powers Act. And most probably either it will be withdrawn from all the entire state, otherwise only few districts will be left in the upcoming future for Armed Force Special Powers Act. That is the step-by-step scenario. And once this Armed Force Special Powers Act is withdrawn from the territory, then again free movement of the people, economic investments, tourism options, they all can bring the better livelihood. That means if it is withdrawn, economic decisions can be there, promotion of tourism can be there, infrastructure connectivity can be there, better livelihood, because for the investment you require peace, for the investment you require public trust. So if already it's a disturbed area, there will be hesitation from the investors or the industry to invest the money. And in the present scenario, government is also investing lot of money for infrastructure growth, and that is with the help of Ministry for Development of Northeastern region, plus Northeastern Zonal Council getting a huge support from the central government. And not just that, even the Niti Aayog has also made a special Northeast Development Forum as a unit within the Niti Aayog. So every step is taken place in order to promote infrastructure there, connectivity there. So it's a rational decision to think about withdrawal of this. However, government have to be cautious also in order to maintain law and order, because recently in the state of Manipur, certain inhuman activities have been highlighted, or heinous crimes were reported where the crime against women have taken place. But again, these are law and order problem, and just by declaring that point as a complete disturbed area will defeat the objectives of overall prosperity for the future. These violations should be handled very strongly by the state government, and if they fail to maintain, then they should take the help of the central forces to maintain peace and tranquility in the region. But if the area is declared disturbed, then there will be more restrictions upon the movement of the people, and also extraordinary power in the hands of the armed forces. And wherever the power exists, power may lead to corruption, and absolute power leads to absolute corruption, according to the statement by Lord Acton. And that statement is absolutely correct. So we may use that type of statement for the concluding remark. Next one, moving to the next question. 6C. So this is about the Swachh Bharat Abhiyan is by far the most significant cleanliness campaign by the government of India. Comment. So this is basically now the fourth question on the scheme. Fourth question, and this is Swachh Bharat Abhiyan. So when it was introduced, October 2014. So it's a Gandhian philosophy of Swachhata, sanitation. As a result, the Swachh Bharat campaign was also on the day of Gandhi Jayanti 2014 has been launched across the country. And in this context, the idea is to achieve the cleanliness drive. And it is also true because of the Swachh Bharat, we are getting open defecation free ODF status to various villages and even states. That is positive side. Because of this, we are also improving very significantly on health standards plus reduction in diseases which are usually waterborne diseases and may be affected because of that open defecation. So as a result, there is a significant decline, and you may use for this purpose National Family Health Survey data with respect to this overall idea. And central government is even organizing Swachhata Pakhwada, that is like a campaign. Pakhwada is a campaign only in the consultation with various ministries and departments to create more awareness. So as a result, this particular program has played a very significant role in bringing behavioral changes. Behavioral changes in the society, and it is supported by the government in terms of infrastructure support, funding support. But the challenge is whether the society will maintain this behavioral change, or after 2 years, 3 years, they will return back to their older practices. Because at the end of the day, government can bring a policy, decision, but its successful execution will depend upon the people's participation. So if the people will return back to their older habits, then all these policies programs will result into a future failure. Otherwise, intent of the policy is good. Implementation has also taken place in a very positive manner. Yes, 2-3 negative reports have also been reported from certain parts, like toilets have been converted into some shops by the villagers, or in certain parts of the Delhi where the toilets were constructed, they have been converted now into ATM, that by the local municipality. So that's a failure or misuse, because government support got over and maybe the funding has been reduced, so they have started converting them into some other means programs, which is not at all even the desired outcome of such a positive policy step. Is it? So more positive with 1 or 2 negative consequences of bad example can be used just to create a caution about the policy decision. Next one, question number 7A. The accountability of the executive to the parliament in the domain of financial administration is secured through CAG report discuss. So basically it's a direct question about what is the role of the CAG report and how it helps for legislative control over executive. So to structure this answer, in the first part we will use a constitutional provision, and this is Article 151. This Article 151 talks about annual report, and this annual report shall be submitted to the President, and from President this report will go to the Parliament, and when the report goes to the Parliament, there it is referred to a committee called Public Accounts Committee. So think about the sequence. This is all going to be explained in the pointer form, and then the PAC will examine report, and on that basis the PAC can submit a general report to Speaker. And when the PAC is examining the report, they can take the help of CAG. So in this way, the CAG can act as a friend, philosopher and guide to the Public Accounts Committee, and CAG helps the PAC to understand the technicality of the report, methodology adopted in the calculation of the losses, irregularities by the executive, and that way the CAG assists the Public Accounts Committee in exercising legislative control over executive. All these are in the positive way. Then it's a question about discuss. So you need to also include advantages, and more focus is also simultaneously on. For limitations, we can use a scholar, Paul H. Appleby. He made some criticisms about the Indian CAG report, that it is post-mortem in nature and the report is not in a position to recover the losses. Plus, in the current time period, reports are too lengthy and they are not discussed in detail. Only random discussions can happen. And in those scenarios, there is no follow-up of the action taken on the basis of the PAC's recommendation. These kind of criticisms we can use against this office of the CAG's report. Means the reports are too lengthy, post-mortem in nature, that's an idea, post-mortem in nature, plus random discussions, rarely follow-ups are done, as a result, the criticism side is to be included in order to maintain this balance of the answer. That is about this question, accountability of the executive to the parliament in domain of financial administration. So first and second page is about CAG, constitutional provision, plus that is the report submitted to the parliament examined by the PAC, how CAG is acting as a friend, philosopher and guide to the PAC. And the second part will take this evaluation into consideration to make a balanced answer. And if space is still there, you may suggest reforms, because there's a content also available, so reforms can also be suggested. And it's like second ARC recommendations can be used, that there should be proper monitoring, report should be regularly tabled, PAC should hold the discussion in a time bound manner. That type of idea can be included to make this control more and more effective. That is about the question. Next one. The government response to the Supreme Court's judgment on the police reform has been lackadaisical. The reasons are multiple and multidimensional. Discuss. So it's a direct question on police reforms. And to approach this, one, we will go with constitutional provision. That means the subject is in the state list. That's the case. Government earlier appointed just name of few committees. On police reforms. So at least two can be mentioned. One, National Police Commission or Dharamvira Commission, appointed way back in 1977. That was the first commission to recommend police reforms. And on the basis of this commission's report, there has been a case called Prakash Singh versus Union of India, in which the Supreme Court gave directions. This will be in the introduction and first explanation part that how this situation has taken place. Then at that time of this Supreme Court's discussion, there was also Soli Sorabji committee to draft Model Police Act. So few provisions of this Model Police Act has been used by the Supreme Court in order to give directives, and it is like there should be State Security Commission for the appointment of the DG and the higher level functionaries for the transparency, and there should be a fixed tenure. Plus, we also have to go for the modernization of police. These are the kind of directions which have been provided by the Supreme Court. And once you explain this part, then comes the second part, which is about status of reforms, which will show ecclesiastical state of art by the state government with respect to the police reform. It's like lack of coordination by the state government with respect to the police reforms. And for that purpose, this is according to an answer submitted to the parliamentary question. 15 state governments have amended their State Police Act. Think about it, we have 28 states and we have 3 union territories with the legislative assembly, exclude Delhi, so still 2 legislative assemblies with the 2 UTs with the legislative assemblies exist, so total 30 territories in that regard, and only 15 have taken the initiative to amend their state. So this lack of coordination by the state will be defeating the objective of the police reforms. Not just that, state also complained about funds for police modernization. That is a genuine criticism, but state are using that money for various types of freebies. Now the states are getting more money from the 14th Finance Commission's recommendation. So most bigger problem is political will rather than scarcity of the funds. There is a need to separate investigation and prosecution. That is the concern. There is a need to provide training. There is need to adopt computerization, even EFIR. Recently, Law Commission was of the view that we can go for the registration of electronic FIR in order to speed up the registration of the system. Otherwise, people do not, police station, some of them political reasons, they do not even register the FIR. Matter reaches to PIL, then court give directives to the police to register FIR and investigate into the matter, and the matter become high profile political matter. Therefore, to prevent all that type of atrocities, EFIR from any place can be recorded and can be registered by the police. In the era of technology, this is a very common thing. But because matter is lack of political will, politicization, as a result, this police reform is still a distant dream in our country. Professionalization of the police force is one of the most important scenario of the modern day policing. We require to have a people's participation in the police complaint authority. We don't have police complaint authority. So imagine if there's a complaint against a police. As a common layman, if police start unnecessarily targeting me, harassing me for making statements about the political party or other, where shall I approach and register a complaint? Or sometimes we read in the newspaper that even the police, there's a women participation is increasing in the police. And one very sad news came from the Delhi in the newspapers about that even a constable, a women constable was also preparing for the civils examination, and she was getting pressurized by her senior for the sexual favors in order to grant the leave, maybe the illicit relationship things, and later on she have been disappeared from the last 2 years, and now the senior has been arrested, and he has accepted the murder. Think about, the protector is also becoming the murderer, law enforcers are also becoming the murderer. So in that scenario where you will approach, register complaint about the police, there is a need for better policing on the model lines. We are still running Indian Police Act on the British lines, so legacy is coming, domination thought process is there. We require to make our police on modern lines. These ideas we can use in concluding remarks as a way forward, and you may use in this case either Model Police Act recommendation, otherwise second ARC ideas to support your view of police reforms. Third one, 7C, disaster can push the world's poverty deeper into poverty. Disaster can push the world's poorest deeper into poverty. Do you think that a comprehensive strategy to deal with such vulnerability is required? And the statement is correct. Disaster disrupts the development, and disaster takes us few years or few decades back depending upon the intensity of the disaster, and we as a country are prone to different types of disaster. Cyclones, landslide, earthquake, forest fire, flood, all type of disasters are possibly existing in our country. In this context, what we should answer is equally important fact to be mentioned. So we will structure this answer in intro part. We may talk about disaster, that what disaster is, and then in explanation part we may focus upon one, that we have a Disaster Management Act 2005 which talks about legal framework, and then simultaneously after writing about this briefly we will include National Disaster Management Plan 2016, which was adopted in accordance with Sendai framework. The Sendai framework on disaster management came in 2015. So in line of this 2015 Sendai framework on disaster management, we have developed our National Disaster Management Plan. So just 4 to 5. Build back better and do not allow the education, health facility to suffer during the stage of disaster. These type of components are mentioned under this National Disaster Management Plan adopted in 2016. So 5-6 features will be more than enough in order to structure this answer, as it's just a 10 marker question. Moving on to the last set of question number 8. In the context of second ARC recommendation, evaluate public-private partnership as a mode of implementing infrastructure project. Now here there are two statements combined together. One, the PPP regarding recommendations of the second ARC, and implementing infrastructure project. So as a student, I may have not in the memory that second ARC recommended anything to PPP, because as a person, when we study public-private partnership, we study them in paper 1, unit number 4, organization, and we usually focus upon this aspect of infrastructure, rail, road, transport, anything. But the ARC2, they gave recommendation of PPP in the context of e-governance. For e-governance, we have to develop infrastructure. For e-governance, we have to develop the digital database. We have to provide the training. That is the idea. So if that recommendation is in your mind, you will be in a better position to structure this answer. Otherwise, it may create a confusion that how come PPP related recommendations have been given. So for that clarity, I am clarifying with you. With respect to PPP, we study a committee that is, it's in 2015. Government of India appointed a committee to study the public-private partnership projects, and that committee is not used or referred by the second ARC. But second ARC has made recommendation with respect to the e-governance in PPP. So as a result, this appears a slightly confusing statement, and to structure this answer, what you may use second ARC, PPP for e-governance, and accordingly, after brief explanation of this portion, that means page 1 or 1.5, then we will approach to the PPP in infrastructure, which is recommended by another committee, and this is not the second ARC. That way you can structure this answer as per its requirement. Is it? So we require PPP for developing infrastructure. So if infrastructure you are taking in the context of road, health, education, you may use the different example for this, or port, airport, drinking water. So different type of examples we may use for these all the different sector, like airport. So GMR Group, Adani Infra, they are supporting the country for development of airport. Port infrastructure, Adani Port and other ports companies are also participating for improvement of the port system. For road construction, so many infrastructure companies are working from India as well as abroad for the National Highway Development Program, or now the present name Bharatmala. It's getting outsourced with the help of private sector. For education, Shiksha Mitra. For the health purpose, Asha. For the public convenience, that is toilet construction, Sulabh complexes, they are also example of PPP, which are working in different sector. So it's up to you how you present this structure of the answer, and I suggest initially we should talk about ARC's recommendation for e-governance, which will be according to requirement of question, and second part PPP, you may go for the wider understanding of this topic to structure it according to requirement of the question. That is an idea for section A. Section B, India in 2011 ratified the UN Convention Against Corruption, evaluate the existing legal framework for fulfillment of this commitment. So it's a direct question, legal framework for fighting corruption in India, and we have wider list of such rules and regulation to fight against corruption. And it's a 20 marker, so you have scope. Initially define what is corruption and its consequences. That can be the first part, a brief introduction and consequences of corruption, and thereafter focus on legal framework. So when we are talking about this legal framework, imagine the number of laws we have. Income Tax Act 1961, Customs Act, these are the older one, 1962, Benami Transaction Prohibition Act This was recently amended in 2016. Originally, it came in 1988. Recently amended in 2016. Foreign Exchange Management Act, FEMA, 1999, in some it's written as 2000, came for implementation. Then RTI, 2005. Then also we have Lokpal, 2013. Whistleblower Protection Act, 2013. Insolvency and Bankruptcy Code, 2016. These all are list of legal framework to fight with the corrupt or recover the money, and writing a 2-3 line on each of them will take us to a wider detailed explanation. And then comes the problem, lack of coordination between the agency, or means the people are running away from the country, so lack of coordination with the foreign territory, isn't it? Lack of awareness about such complexities of the corruption in the law enforcement agency. These type of criticism we will use in order to evaluate these points. We do have list of wider laws to deal with this corrupt practices. And now the last question. This is also a scheme based. So finally, this is the fifth question on the scheme, and the scheme is Rurban. Shyama Prasad Mukherjee Rurban Mission is a cluster-based approach of converging rural development efforts of different departments of the government. Comment. The statement is correct and it is the guiding statement for this mission. And the idea is this Rurban mission in 2023 current year, government has expanded its operations and government have identified 298 clusters to link them with the smart city initiatives. So we have 100 smart cities initiative, and nearby these 100 smart cities, a distant away, we may go for the development of these 298 clusters, so that a contiguous area will get developed for this purpose. And under this Rurban mission, population base will be taken. Population base will be 25,000 to 50,000 in the plains. And this population base will be 5,000 to 15,000 in the coastal and hilly areas. That is its requirement side, and it's just a 10 marker question. Plus in this one there are 14 components. So basically we wanted to provide urban type of facilities in the rural area. That's why the combination is rural plus urban and it became Rurban. Is it? Rural plus urban, it became Rurban. So we wanted to provide urban type facility in the rural area. And that's why there are components of this mission, and these components can be like skill development. Plus it is also about agro processing. 14 are there, at least 5-6 whichever we remember will be sufficient enough. Sanitation. Then piped water supply. Then solid waste management. Solid and liquid, both waste management are there. Mobile health units. So let's say these 5-6 sectors we are using. Now these all depends upon different ministries and departments, and therefore the question is the same, that it is an effort of different departments of the government to provide coverage, and these things to be implemented in support with Gram Panchayat to identify the beneficiaries and its implementation. So statement is completely correct, and we will explain component of Rurban when it was introduced and what is the data. That is 298 cluster based approach has to be developed, and it requires the combination of 14 different departments for its implementation, and that will justify the statement as per the requirement of this question. Even street light, village street, LPG gas connection, digital literacy, they are also the part of this Rurban mission. So in that way, we can structure this answer and will help us to fetch a score. On the basis of this entire paper and from the last few years paper, what we can observe is the paper is coming now in an average way, plus this require a combination of a constitutional provision, concept, schemes, and recent issues, plus for reforms we require ARC, otherwise any another commission which is formulated by the government. And if we follow this, we will develop a problem solving approach as an administrator, which is the requirement of the modern day public administrators after selection. That's why the subject is giving us insight, and the paper is up to the expectations. It's not that much difficult and it's not that much easy also. So it's an average one, and let's hope the marking will be liberal, and maybe the score in the puppet will also be on a higher side depending upon the way how the students have performed in the exam. That is all. Those who have written, all the best to all of you in order to score a higher marks and succeed in your civil services journey. Thank you so much. We will meet again anytime in future for any another particular topic. That's all. Thank you so much.